We're going to talk about Justice Scalia, one of the most well-known and certainly the most outspoken justice of the last couple of generations on the United States Supreme Court. Talk about his legacy, what it is really that he has left behind. What has he left behind? At this point, you could probably forget most of what you heard by the commentators right after he passed away. I mean, some of the commentators, I was just startled by some of the things they were saying. Well, the greatest this, the greatest that. And then 2 weeks later, they would write articles saying what a dreadful human being and justice he was. So, and you wonder if they ever read one of his opinions. And the impact of his departure, well, we already know that part of the impact is that the United States Supreme Court has only 8 members. Right? There's a vacancy, and who knows when that vacancy is going to be filled. Certainly, one of the impacts of his departure immediately is that the court, which is divided along partisan lines, notice I didn't say philosophical lines, I didn't say jurisprudential lines, partisan lines, because the court by and large votes like for Republicans and for Democrats. If you took the kinds of issues that come before the United States Supreme Court and you said, well, if I brought the same kind of issue before the United States Senate or the House of Representatives, how would the Republicans vote? How would the Democrats vote? That's basically the way the justices on this court vote. I can tell you right off the bat, I think it is a dreadful court at this particular time, not because it's conservative or liberal. Some people think it's too conservative, some people think it's too liberal. It's a dreadful court because it's partisan. Not because it's political. The court is always political. It's been political from day one. The kinds of issues that come before the United States Supreme Court are necessarily political. Political in the sense that they deal with rights of American citizens, and they deal with obligations of American citizens. They deal with the authority of government, what government is permitted to do, what government is not permitted to do. Those are political questions. These are not legalistic questions, right? So if we were to ask whether or not a woman ought to have a right to choose, that's not a legalistic question. That's a question that I would much prefer to leave to my 92-year-old mother than to anybody on the United States Supreme Court. 6 kids, 17 grandchildren, lots of life under her belt, right? She knows about life. She knows about life. This is not a matter of how you interpret a statute or how you interpret provisions. So the court's always political in that sense. The problem with the current court is that it is partisan. It is Republican versus Democrat. And that's very, very different than the court's been throughout history. There have been other periods in our history where the court was like that. Certainly it was like that at the very beginning. People don't like to hear that, but it was like that at the very beginning. Washington and Adams appointed all Federalists, partisan Federalists. Jefferson came along, and what did he do? He appointed Jeffersonians. Isn't that pretty neat? I mean, he appointed people who belonged to a party or a political movement under his own name. And he and Madison appointed Jeffersonians, right? And they were always clashing. But other than that, when we hear, well, they're political, they're this, well, it's always been like that. Not true. Not true. So, for example, today I was talking to my students about some of the cases in the 1940s and the 1950s. Where you wouldn't have decisions where you had all the Republicans on one side, all the Democrats on the other side. No, you might have Justice Jackson, right, an FDR appointee, liberal Democrat on one side, and you would have Felix Frankfurter, another liberal Democrat appointed by FDR, on the other side. You might have Hugo Black on one side, right, and then you might have another Democratic appointee on the other side. You rarely get that today with this court on the tough issues. It's almost always the Republicans versus the Democrats. And then you have Justice Kennedy, as you all know, is viewed as the swing vote. And he is the swing vote. One of the ways in which we get some insight into Justice Scalia is to talk about one of the other appointees of President Ronald Reagan. President Ronald Reagan. And that is Justice Kennedy. There is a big difference between those two. And the story behind Justice Kennedy I think is very enlightening as to why he is the swing vote and why he doesn't vote strictly like a Republican, which he doesn't. Sometimes he votes like a Democrat, sometimes he votes like a Republican. In other words, he votes like a judge, right? When I was down in Washington as a Supreme Court fellow under Chief Justice Berger, President Reagan was about to announce his nominee for the United States Supreme Court. Robert Bork had been nominated, and that nomination imploded. So Reagan was going to nominate Justice Anthony Kennedy on the recommendation of James Baker, his chief of staff. James Baker, who was a fairly moderate Republican. So I knew some of the people who were also my classmates at the University of Virginia. I knew some of them who had been working with the Attorney General of the United States at the same time. So I called them up because I had heard that Reagan was going to be announcing his nominee it was either 10 or 11 in the morning. So I called up my buddies that were working for Attorney General Meese at the time. I said, so what's Reagan going to do? I don't want to offend anybody, but this is what they told me. Reagan is going to appoint that homo lover, Justice Kennedy. We're going to run over there and stop him. Well, about an hour later, Reagan's there announcing his nominee, and it's not Justice Kennedy. Justice Kennedy was on the plane back to California. He nominated Douglas Ginsburg. Douglas Ginsburg then had to withdraw his nomination because he had smoked marijuana, which to some people is worse than serial murder. So he had smoked marijuana. They were all aghast. They withdrew his nomination. By this point, Reagan was absolutely upset with the right-wingers in his cabinet and said, I'm going with Jim Baker's choice of Anthony Kennedy. And so that's why we have Anthony Kennedy, someone who was really suspected by the ultra-conservatives. And that's not to suggest that they're right or they're wrong, just what they are. Somebody who the ultra-conservatives in the Reagan administration did not want. And why didn't they want him? They didn't want him because they were pretty darn sure he was going to be voting the way he has been voting, not like a straight Republican or a straight conservative. And they also knew they had good reason to believe that he was going to be very, very strong on gay and lesbian rights, which he certainly has been. Scalia, on the other hand, was known to be very, very conservative when he was a professor both at the University of Virginia and at the University of Chicago. And then when he was on the Federal Appeals Court in Washington, D.C., he was known for being very, very conservative, very bright, very conservative, and Italian. There had never been an Italian on the United States Supreme Court. Which brings me to the next slide. This is my year at the United States Supreme Court. And at the end of the year, at the end of the fellowship year, the Chief Justice throws a huge party. Officially, it's for the two fellows, the Chief's two fellows. Okay, that's not why. It's because they love having parties in Washington, D.C. So there was this party, and sure enough, all the justices are there, the cabinet's there, who's who in Washington is there. The place it's just jammed. It's in the Great Hall of the United States Supreme Court. And this is one of the last times I was with Justice Scalia during that year. The first time I was with Justice Scalia, which is related to his being Italian and my being Italian, was about 2 weeks into my fellowship. He had just recently been appointed, just recently confirmed by the United States Senate. He, again, first Italian-American on the United States Supreme Court. The Chief Justice sets up a breakfast for his fellows, right? And his interns, a couple of his interns, and Justice Scalia. So we're in the Chief Justice's annex waiting for Justice Scalia to come in for breakfast. The Chief's not there. He's going to leave us alone with Scalia. So we're sitting there. Scalia walks into the room. I have never seen this man before. I've never seen him before. I'm obviously not Scandinavian. He looks at me. Never seen this man before. He looks at me and he says, I don't understand why I'm getting invited to speak by all these Italian groups. He says to me, well, he's addressing all of us, but he's looking at me. He says, I wasn't appointed because I'm Italian. I was appointed on merit. That told me a lot about this guy. Told me a lot about this. First of all, it wasn't even true, because Reagan had gone to the Columbus Club in New York City and promised them that he was going to put an Italian on the court. Number two, which I, of course, was thrilled about. But number two, I mean, you know, if you had to list the top 50 people that should be appointed to the Supreme Court, Justice Scalia certainly would have been among the 50, but to think that he was the best person possible for the United States Supreme Court, I mean, is another thing. It tells us a lot about him. So I did say to him at that time, I said, well, you know, my mother and my father know absolutely nothing about you, except for the fact that you're Italian, and that's why they're proud of you. He says, well, I guess so. Years later, however, he did start accepting invitations to just about every Italian organization invitation. And in fact, a couple of years ago, there was a PBS special on Italian Americans, and they interviewed him. And he actually said in his interview, when I first got to the court, I didn't understand what this meant for Italian Americans. God knows how he could not understand that. But in any event, so that's me and Justice Scalia. Okay, what we're going to look at, Justice Scalia in the First Amendment with religion and with campaign finance. Second Amendment, guns. Fourth Amendment, that's search and seizure, and particularly with regard to technological searches, because of course, that's really much of the concern today. That's much of the concern. Of course, a lot of it also happens to do with stop and frisks, especially in the urban areas, you know, where just so happens to be that 90% of the individuals stopped and frisked are minority, and 90% of them are totally innocent of anything. So you wonder what the heck the suspicion was. The Eighth Amendment, cruel and unusual punishment and the death penalty. The 14th Amendment, right, which is the Civil War Amendment, guaranteeing equal protection and due process, and guaranteeing it against state encroachments, right? We're going to take a look at affirmative action, women's rights and gay rights. He wasn't in favor of any of them. Religious liberty. I guarantee this is going to surprise you. This is going to surprise you because, you know, during the presidential primaries, I kept hearing Senator Cruz saying that he wanted to appoint justices to the Supreme Court who were really strong on religious liberty. Ted Cruz is pretty darn smart, and he's knowledgeable. He had to know that was a lie. He had to know that was a lie. Oregon versus Smith, 1990. 1990. Scalia writes the majority for the court. There's 5 in his opinion. There's 1 that's a concurring opinion by Justice O'Connor. So she's agreeing with the result in the case, but she's not agreeing, not at all, with Scalia's opinion. And then there are the 3 dissenters. Don't agree with his analysis, and they don't agree with his result. What's the case about? The case is about the Native American group in Oregon who have been smoking marijuana in their religious rituals for hundreds of years. So Oregon has a law, like all states do, right, barring the possession, the use of illicit drugs, illegal drugs. One of them happened to be peyote. So this Native American group sought an exemption. They sought an exemption from it. Say, look, this is our religious practice. This is what we do, right? Catholics have Holy Communion, right? Jews wear their yarmulkes, and they get exemptions when there are state laws saying that they're not allowed to wear headgear playing sports. They said lots of groups get exemptions. This is our sincere religious belief. You know it is. We've been doing it for hundreds of years. The court, speaking through Scalia, acknowledged the fact that this was a sincere religious practice, one that they'd been engaged in for hundreds of years. But then what he says is, we have never held that an individual's religious belief excuse him from compliance with an otherwise valid law. Think about that for a minute. You've got the Constitution, right? And we're not talking about something buried in the Constitution. We're talking about the first clause, right? Religious liberty in the First Amendment. You have First Amendment, religious freedom, and then you have any valid law, and he's saying that any valid law trumps religious freedom. Trumps religious, well, you all know. I mean, you don't have to be lawyers to understand that's hogwash. That's total hogwash. What's also hogwash is that we have never held that religious objection entitles somebody to an exemption. That was a complete lie, a complete and utter lie. In fact, we had, a couple of years after this case, we had a symposium at the law school in which we had religious scholars, we had legal scholars, we had history scholars. We could not find one to defend this opinion. We could not find one, not one. Republicans, Democrats, liberals, conservatives, we could not find one. And then he says, laws need only be neutral and reasonable. Just think about that for a minute. First of all, if a law is not neutral, that is, if it actually discriminates or targets one group as opposed to another, it's invalid anyway as a violation of equal protection. Reasonable, if it's not reasonable, if it's an illegitimate law, it violates due process. You don't need free exercise. So free exercise of religion is down the tubes. It's down the tubes. So, never held. Okay, Justice O'Connor's opinion, where in a much nicer way than I have done, she calls him a liar. She spells out, but everybody knows that that's exactly what she was talking about. She says, yeah, I understand these are very, very important laws, these drug laws, so I'll go ahead with the result. But you are now contradicting our religious freedom jurisprudence. First of all, do you remember the case? Do you remember the case where the Jehovah's Witnesses did not want to pledge allegiance to the flag? They didn't want to salute the flag. This was during World War II, right? And what happened? Speaking through Justice Robert Jackson, thank you. Justice Robert Jackson, speaking for the court, says they're entitled to an exemption. They are entitled to an exemption. If there's anything about the Constitution, he says if there's any fixed star in our constitutional constellation, it is that no official, high or petty, shall prescribe what shall be orthodox in politics, nationalism, or religion. That we cannot force the Jehovah's Witnesses to violate their religion. They get an exemption. So the parents who were convicted because their children wouldn't pledge allegiance to the flag, their convictions were overturned. And the children, Jehovah's Witness children who were thrown out of school, they got to go back. Exemption for them. Number two, what about Sherbert versus Werner? That's another landmark case. Sherbert versus Werner had to do with Seventh-day Adventists. They didn't want to work, for religious reasons, on Saturday. That's their Sabbath. So what happened was, the state said, you're not entitled to unemployment benefits because you wrongfully chose not to work on Saturday. The United States Supreme Court threw that one out and said, no, you cannot force individuals to choose between their religion on the one hand and a government benefit on the other. And the court says the only time a law can defeat religious freedom is, it's what we lawyers call a strict scrutiny test. Number one, government's got a compelling reason to be doing what it's doing. It's like really, really, really important what the government's doing. And number two, The government can't do it any other way except to intrude upon religion. And he said, in this case, of course you can do it some other way, accommodate the Saturday Sabbatarians. Another exemption. Then there's Wisconsin versus Yoder. My former boss, Chief Justice Berger. Wisconsin versus Yoder. The Amish, right? They don't want to send their children to school beyond the age of 14 for religious reasons because they believe that the children will be corrupted by worldly influences. Wisconsin says, no, like most schools, most states, no, you must send your children to school up to a certain age. Case gets to the United States Supreme Court. Chief Justice Berger for the court says, no, they're entitled for an exemption. Yes, we know that education is a compelling government interest. But you don't have to force the Amish to send their kids. They do a pretty darn good job of educating their children. And they do a pretty darn good job of turning their children into good citizens. So you don't need to require them to violate their religion. That's another exemption. But according to Scalia, we've never held that. We've never held that. I mean, what can you say? This is one. In fact, I just taught free exercise of religion today in class. I mean, what do you say? I mean, I don't know. Just what do you say? What do you say? Now you say, but what about these more recent cases, like the Hobby Lobby case, right? Like the Hobby Lobby case, where in Obamacare, right, there was a contraceptive mandate, right? And the conservatives on the court, including Scalia, said that Hobby Lobby was entitled to the exemption, right? There was no complaining that, oh, religious objectors are going to become law unto themselves, the republic is going to fall into chaos. There was none of that kind of nonsense, right? What about that, you say? Well, how do you jive that with Oregon versus Smith? Hobby Lobby has nothing to do with the First Amendment. Has nothing to do with the First Amendment. Hobby Lobby has to do with a law, the Religious Freedom Restoration Act, which was enacted by Congress very, very shortly after Oregon versus Smith, because everybody in the Senate and the House of Representatives was so repulsed by Oregon versus Smith that they enacted the Religious Freedom Restoration Act to restore religious freedom, to restore it to what it had been in the flag salute case, in the Amish case, and in the Seventh-day Adventist case. So, with regard to federal laws, not state laws, but with regard to federal laws, before an individual or an organization can be required to violate their religion, the government's got to prove we've got a really, really overriding reason for doing this. And number two, it's the only way we can do it. It's the only way we can do it. In the Hobby Lobby case, right, there wasn't any First Amendment issue because Hobby Lobby definitely would have lost under the First Amendment because Obamacare and the contraceptive mandate are otherwise valid laws. Perfectly valid. May not like them, you may like them, but they're valid laws. The only problem is religious freedom. First Amendment gets you nowhere. So they argued under the Religious Freedom Restoration Act. What does that mean? That means that for federal laws, there's no First Amendment protection to speak of. None whatsoever. But there's federal statutory protection. For state laws, you got nothing. You've got nothing protecting religious freedom unless the state adopts protections for religious freedom. Otherwise, if somebody goes to a state Supreme Court, the Vermont Supreme Court, and says, look, my religious freedom is being violated, if we're talking about the federal Constitution, all the Vermont Supreme Court says is, well, it's an otherwise valid law. That's the end of it. Unless Vermont, like New York, like every other state, unless they have their own special protections for religious freedom, there's nothing. There's nothing. And as you can imagine, the result of that has been that you get the exact same kinds of religious freedom questions in the different states. And you'll get some states that will adopt Oregon versus Smith, so religious objectors get no protection. Other states, say, no, we are sticking with Barnett, Sherbet versus Werner, Wisconsin versus Yoder, and they do protect their citizens' religious freedom. So, another thing that's really, really interesting about this, I mentioned Scalia, that, all of a sudden he switched sides and he loved, the last few years he loved religious freedom. Why did he love religious freedom? Because the religious objectors happened to be very traditional, right? Very traditional and evangelical religions. That's why he suddenly loved them. And it's not just him. It's not just him. That's hypocritical. In these other cases I spoke about, where religious freedom was protected, for the Amish, for the Seventh-day Adventists, for the Jehovah's Witnesses, in cases before that for the Quakers, who was defending them? The liberals. And the ACLU. The ACLU loved religious freedom. Now, all the liberals are against it. And the ACLU now argues, what do they argue? They argue Oregon versus Smith. They were on the other side in Oregon versus Smith, arguing like crazy that religious freedom had to be protected by the compelling only, by the strict scrutiny test. Compelling government interest, this is the only way the government can do it. Now the ACLU is always on the other side, right? Because now it's about contraception, it's about abortion, it's about gay rights. So the hell with the religious freedom. These questions are tough. My only point is that, okay, and getting back initially to Scalia, is that he didn't like religious freedom at all when it was minority religions. When it became Catholics, loved them, right? Yeah. As my grandfather used to say, the world's a fake. All righty. Campaign finance. It's the Citizens United case. I heard that from somebody. Okay. Citizens United has now become the whipping boy for everything we don't like about money in politics. Citizens United actually had to do with a particular provision of the campaign finance law that prohibited political communications within 30 days of a primary and 60 days of the presidential election. Just think of that. 30 days before a primary and 60 days of a presidential election, no political communication. So if a few of us in this classroom wanted to get together and say we wanted to put together a documentary, as what was at issue in Citizens United, a documentary criticizing Hillary Clinton. And what is it, 21 days now before the election? We're not allowed to do it. Just us in this classroom. Wait a minute, you mean we can't put together a documentary? We can't put together an ad criticizing Hillary Clinton? We can't put together an ad criticizing Donald Trump? That's what Citizens United was about. Citizens United was not about individuals or organizations giving money to political candidates. It was not about that. We hear about it all the time as though that's what it was about, but it was not. It was literally about a prohibition against pure political speech, right, within a certain period before an election. Nevertheless, Citizens United, it's 5-4. Well, of course it's 5-4. You know it's going to be 5-4. That's this court. You got the Republicans. They love, these corporations that are spending lots of money to put together these documentaries. And don't forget, this was a documentary against Hillary Clinton, right? So they were salivating about that one. They got to save that one, right? It was a documentary against Hillary Clinton. So you had the conservatives on the court, Republicans on the court, loved it. And so hated the law that didn't allow it. The liberals, of course, who we always thought were in favor of free speech, they all of a sudden hated it. And they loved the law that didn't allow it, that didn't allow this speech. Getting back to Scalia, if speech can be prohibited, now let's back up a little. What is he known for? Being a textualist, an originalist. You just look at the text. Okay, I'm sorry, but the First Amendment says speech. speech. Citizens United was about being able to spend money to produce a political communication. Now, you may not be a textualist. I'm certainly not a textualist. But you know, if you go around the country insisting you're a textualist, it's pretty darn difficult to say, well, you know, the First Amendment says speech, because that's all it says. It doesn't say expression. It doesn't say communication. It doesn't say spending money to put one together. It says pure speech. We actually had textualists in the history of the United States Supreme Court. Hugo Black from Alabama, who was appointed by FDR. He was a textualist. And he stuck to his guns. He said speech is speech is speech. Doesn't include black armbands. It doesn't include a jacket that says, again, excuse me, fuck the draft. It doesn't include that. It includes speech. It comes out of your mouth. Because the founders understood there's a big difference between speech, which by and large is harmful, right? Sticks and stones can break my bones, right? He was a big fan of that, right? Where expressive activities can be harmful. But Scalia, the textualist, all of a sudden spending money to put together a political communication against Hillary Clinton, that was speech. And then he says, which of course is true, if speech can be prohibited because it leads to moral decay and does not serve public ends, there's no limit to the government's censorship power. Absolutely true. Then the liberals who didn't like Citizens United, and I'm talking about this particular case, this not the case, the subsequent case, which really was about donating money to politicians and political parties. That was the McCutcheon case. That came after this one. The Supreme Court did away with limits on that too. But with regard to this case, one of the complaints that the liberals had was, wait a minute, it's a corporation. Citizens United's a corporation. When the heck are they entitled to constitutional rights? I mean, I'm sorry, I'm a liberal Democrat, but you know, that's complete hogwash. Corporations from the founding have been entitled to constitutional rights. You prosecute a corporation, sorry, proof beyond a reasonable doubt. Sorry, they have right to counsel. Sorry, they get to confront their witnesses, right? And then we have lots of corporations who've expressed themselves, and they're protected. They are protected by the First Amendment. So that was kind of nonsense. That kind of was nonsense. So Scalia on this one, I think you got to give him a pass, except for the fact that he's talking about speech, and we know darn well that what's involved is not the purest speech, which again shouldn't bother most people, but if you're going around saying just follow the text, right? Well, then it's a little hard to go from text to spending money to put together a documentary criticizing Hillary Clinton. Right to bear arms. This is another gem. D.C. versus Heller. The question in this case was, as you know, whether the Second Amendment protects an individual's right to bear arms. Now, again, you know, there are many liberals and conservatives, Republicans and Democrats who look at the history of this country. They look at the history of this country and they say, you know, the framers, the founders, the American people have long believed that having a gun, having weapons, was necessary for free people in a free society to protect against tyranny, right? But Scalia talks about the Second Amendment. I'm sorry, that's not what the Second Amendment is. The Second Amendment was a protection of the states against the possible tyranny of the federal government. That doesn't mean there wasn't a fundamental right of individuals to bear arms, but it's not in the Second Amendment. It's one of those that just doesn't happen to be mentioned. Most rights are not mentioned in the Bill of Rights. But again, if you go around the country insisting that there are no rights except for the ones that are mentioned in the Bill of Rights, it's pretty hard to say, well, historically, if you think about the founders and the framers, they all believed it was a fundamental right, but it just doesn't happen to be in the Second Amendment. So he tried to hook, right, his result on the Second Amendment. How did he do that? By ignoring half of the Second Amendment, right? And what he says, the prefatory clause, right? It's just a prefatory clause. A well-regulated militia, right? He says it's just a prefatory clause. He announces the purpose, but it's not the only reason for it. Okay. I mean, you're talking about somebody who's stretching. Again, a textualist, right? And somebody who's saying, if it ain't in the Bill of Rights, it ain't there, right? We hear him say that all the time. So what he does is he basically gives a tortured interpretation of the Second Amendment. The result in the case, is it correct? Lots of us think it is correct, whether we like guns or not, right? But the reasoning that this is the Second Amendment, sorry, most scholars would tell you this is not at all what the Second Amendment is about. And then he says, again, somebody who believes in textualism, he says this is the way the Second Amendment should be read. So he now is rewriting the Second Amendment in his opinion. Guarantees an individual's right to possess and carry weapons in case of confrontation. Well, I'm sorry, but that ain't what it says. That's not what it says. There may be such a fundamental right, and I do believe there is such a, but that ain't the Second Amendment. So, but again, it's 5-4. And of course, if we're going to knock Scalia, we have to knock the liberals as well. I mean, the four of them. I mean, it's pretty difficult for a scholar to look at the history of this country and say that this country has not long believed that it was essential to a free society for individuals to have a right to have arms. I mean, it's pretty difficult to make that argument. So right on result, but I mean ridiculous analysis. Technological searches. This is a great one. Oh, they're all great. United States versus Jones. I particularly love this one because when this case was decided, the commentators, especially the liberal commentators, say, man, what a great decision this was. Oh my God, this just proves that, the court isn't always divided along partisan lines. My God, this is a great one. I just think it was Scalia. What a great one. Scalia's got a liberal turn to him. All right. This is what the case is about. The police place a GPS device on a suspect's car. They don't have a warrant. They don't have probable cause. Constitutionally probable cause, that is good reason to believe someone likely committed a crime, right? That is required to get a warrant. They didn't have a warrant. They didn't have probable cause. In the court, apparently, they acknowledged they didn't have any constitutional justification. They didn't have any constitutional justification for placing the GPS on someone's car. Then they electronically monitored the driver for 28 days. No warrant, no probable cause, no constitutional justification. Or as Thurgood Marshall would say, it was unspeakable what their justification was. And so that also often happens. Sometimes when the government can't acknowledge why they were doing something, they just say they didn't have any justification and they don't need one. That's actually what the government argued in this case, that the government argued it didn't need any justification whatsoever for attaching a GPS to someone's car and then monitoring that person's movement for 28 days. You say, how could that possibly be? How could that possibly be? Well, when I tell you that this particular court is dreadful, I'm serious. I'm serious about it. It's dreadful. One of the things this court has done is to create all kinds of exceptions to search and seizure rights. How did they do that? Because they say that virtually nothing's a search. You say, okay, he's exaggerating. Oh, yeah? Suppose, for example, the police in their helicopter hovered over your backyard. They just hovered over your backyard, right? You call up, you say, hey, what the hell's with this helicopter hovering above my backyard? Do they have a warrant? No. They got probable cause? No. They got reasonable suspicion? No. We don't need any. Why? Because it's not a search. What do you mean it's not a search? Well, you don't have any legitimate reason to expect privacy in the airspace above your backyard. And that's exactly what the United States Supreme Court decided in Florida versus Riley. You have no legitimate expectation of privacy in the airspace above your backyard, and therefore, since you don't have any legitimate expectation of privacy in the airspace above your backyard, when the government intrudes upon it, it's not a search. It's not a search. Then there's the dog sniff cases. The dog sniff cases. I'll just give you a few examples so you know that I'm not just exaggerating. Dog sniff cases. The police come out with a dog, right? You're walking down the sidewalk, and they bring the dog along, and the dog starts sniffing you. They literally bring the dog over to you to sniff you, right? They, wait a minute, you got a warrant to be doing this? No. Probable cause? No. Reasonable suspicion? No. Why are you doing it? We don't need a reason. You know why they don't need a reason? Because the United States Supreme Court in several cases has said canine sniffs are not searches. You know why they're not searches? Because everybody knows if you go walking down the sidewalk, somebody's dog's going to come around and sniff your privates. They don't put the private stuff in there. I just added that. But they say everybody knows that, you go to a friend's house, the dog's there. You walk down the sidewalk, a dog's there. So you can't possibly expect privacy from a police dog. I don't think that follows, but the Supreme Court says, and therefore, it's not a search. It's not a search. All right, and I could go on and on. What about your backyard? I talked about your backyard. This is something that will probably hit home to a lot of people living in a state like Vermont. Do you realize that you wake up one morning and you see the police at the far end of your backyard? The far end of your backyard, right? They're far enough away from your house so they actually can't see in through the bathroom window or the bedroom window. So in other words, they're beyond peeping distance. The court calls that beyond the curtilage, right? How many of you have used the term curtilage the past year? Yeah. The court calls that the curtilage, right? Yeah, so that's peeping distance. As long as the police are beyond peeping distance, right? So you go out to far end of your backyard or your acreage and say, what are you doing here? We're looking around. What do you mean you're looking around? You got a warrant? No, probable cause. You know the whole routine. No, we don't need it. Why don't you need it? Because United States versus Oliver, it's not a search. If the police are beyond peeping distance, it's not a search. I'm not kidding. I could go on and on and on. It is so ludicrous. It's absolutely ludicrous. You say, but they're smart people. What's going on? Well, what's going on is they don't want to exclude the evidence. They know darn well that this is actually a search. That's why the police are doing this. They know darn well that if there is actually a search, right, if they acknowledge it's a search, then they have to require a warrant with probable cause. And so if the police engaged in these activities without a warrant and probable cause, then any evidence that was obtained has to be thrown out, can't be used, right? You have a majority of the court that absolutely hates that exclusionary rule. But they don't have the votes to get rid of it entirely. So instead they come up with this nonsense that these searches are not searches. So, get back to this one. The Supreme Court's doctrine that was applicable in this case was called the public access doctrine, meaning that if you're in your car on a roadway, it's public. And therefore, you don't have any expectation of privacy because you're on a public roadway. Why don't I have any expectation of privacy? Oh, because if somebody's walking down the sidewalk, they could see you. Yeah, but they're not running after the car for 28 days, right? And they're not the police. I might expect to pass by a neighbor or a stranger in the neighborhood when I'm on the roadway, but I don't expect the police to be following me for 28 days. So that was the public access doctrine. So what does Scalia do in this case? He says, look, the Fourth Amendment search and seizure is actually about property rights. That's what it's about. It's about property rights. And then the other part of it was, and it's only about those items that are mentioned in the Fourth Amendment. Person, houses, papers, and effects. If it's not a person, a house, a paper, or an effect, whatever that is, right? No search and seizure rights. So what does he say about this? The government trespassed on somebody's property by putting the GPS on the property, on the car. And number two, a car is an effect. It's an effect. So there was a trespass on property, violation of property rights, on an effect. Property, an item mentioned in the Fourth Amendment. All right. He says that's what searches are about. Search and seizure rights are property-based. It's a unanimous decision, but there are four of them writing a separate concurring opinion saying, I'll agree with your result that this was a violation of search and seizure, but not because of any trespass. In fact, with regard to most searches, there isn't any trespass. Are you kidding? First of all, placing a GPS on somebody's car, just that, how much of a trespass is that? Number two, again, most technological searches don't require trespass. What about drones? What about cell phone towers, right? What about that damn helicopter, right? Most searches don't require any trespass whatsoever. And in fact, in 1967, the United States Supreme Court in the Katz case said the Fourth Amendment is not about property, and it's not about the particular items. It's about people's privacy and freedom from intrusion by the government. And in the Katz case, the United States Supreme Court overruled previous cases in which the court insisted on trespass and insisted that it be an item mentioned in the Fourth Amendment. So, for example, you had cases like the Olmsted case. The police put a wiretap on a telephone line. Remember we had telephone lines? Put a tap on the telephone line, listening in on somebody's private conversation. You know what the United States Supreme Court says? No warrant, no probable cause. So what? He doesn't own the telephone line. Telephone company does. And not only that, phone calls aren't mentioned in the Fourth Amendment. You had several cases like that. The Katz case in 1967, the Katz case said, hey, wait a minute, that's not what search and seizure rights are about. They're not just about trespass. They're not just about those particular items. They're about people and people's privacies. Look what he says about Katz. He says, we deviated from that approach in Katz. And now you start to get a sense of Scalia, right or wrong, smart or foolish. He really was about bringing the court back to what it was, bringing the court back to the jurisprudence that it was. And of course, by doing so, really limiting things like the rights of the accused, such as search and seizure rights. And religious liberty when it came to weirdo religions. Right? In the Harmland case, someone is in possession of cocaine, and Michigan imposes life without parole. Life without parole. And the defendant says, well, that's a little excessive. That's a little excessive. You know, cut me some slack here, right? The Scalia writes, well, he writes the opinion for the court. I've got there the majority because if you look at that case, it'll say opinion for the court and it's Scalia, but he actually only got 2 votes. He had 5 votes for the result, but he only had 2 votes for his reasoning. There was actually the other 3 and the 4, so there were actually 7 votes against him for his reasoning. This is his reasoning in the case. Life without parole for possession of cocaine is perfectly fine because the Eighth Amendment doesn't contain any prohibition against excessive punishments. It says excessive fines and excessive bails, but it doesn't say excessive punishment, right? Ever the textualist back again, right? It says with regard to punishment, it says cruel and unusual, but not excessive. And therefore, excessiveness has no place whatsoever in Eighth Amendment jurisprudence. Well, it was him and Justice Thomas. The other 3 Kennedy, O'Connor, and I forget who the third one was. And then with the libs on the court, they said, well, of course there's a disproportionality, an excessiveness component to cruel and unusual. But Scalia couldn't help himself, which is one of the things that's kind of good about Scalia, because after he got through with all the legal analysis, he kind of really told you where he was coming from. And what he told us in this case was that the Eighth Amendment, cruel and unusual prohibition, only forbids punishments such as, this is right out of his opinion, breaking on the wheel, flaying alive, rendering asunder, maiming, mutilating, and scourging. That is the only thing prohibited by the Eighth Amendment. He's back in the Inquisition. He's back in the Inquisition. And actually, there is more to that. Bays v. Rees had to do with lethal injection. The constitutionality of lethal injection. And you see the court's 7, but that's really 3 plus 1 plus 2 plus 1, right? Versus 2. He writes a concurrent, well, the court upholds lethal injection, but he can't help himself. He's not writing the opinion for the court. He can't help himself. He's got to write a concurring opinion, right? Of course, lethal injection is perfectly fine. Lethal injection is perfectly fine. But I have to say something about the dissent by Justice Stevens. Justice Stevens is always worried about an innocent man being executed. It's never happened. It's absolutely never happened. Well, he hasn't been reading the literature. But then he also lets Justice Thomas do the dirty work. And he joins Justice Thomas, and Justice Thomas says, the Eighth Amendment is really about prohibiting burning at the stake. See, if I wasn't quoting, you wouldn't believe me. If I was just, right? If I was just paraphrasing, you wouldn't, it's like my students. They will not believe it. I said, okay, that's why I'm making you read the opinions, right? So burning at the stake, crucifixion, breaking on the wheel. Breaking on the wheel, that's pretty damn liberal, isn't it? Man. So, yeah, that's their view. But it's just the two of them. Affirmative action. Affirmative action. As you can imagine, he loved affirmative action. The Fisher case, and that Fisher case coming from the University of Texas was up and down a few times. Came from the University of Texas, the federal courts in Texas, then up to the United States Supreme Court, and they would send it back, and then it would come back up to the United States Supreme Court. So his concurring opinion, he agrees with the court, the majority of the court, which says, we're going to send this case back to the Federal Appeals Court because we want them to apply what? Strict scrutiny. Remember we were talking about strict scrutiny with regard to religious liberty? That's the test. Compelling interest, it's the only way you can do it. That's the test, the standard constitutional test when a fundamental right is being infringed upon, or when there's a classification such as race being made by the law. So affirmative action, racial preferences, that's a racial classification. So the United States Supreme Court sends the case back to the Federal Appeals Court and says, hey, remember classifications like race? You apply strict scrutiny? Apply strict scrutiny. They send it back down. Scalia says, yeah, I agree with sending it back down, but I agree with sending it back down because affirmative action is not allowed, period. I don't care how strong the government interest is. It is government discrimination on the basis of race, even if we're talking about education, is absolutely prohibited. He also quoted from the Grutter case. The Grutter case, the majority is written by Sandra Day O'Connor. The Grutter case comes out of the University of Michigan. And in the Grutter case, majority of the court, speaking through Sandra Day O'Connor, said, the consideration of race as a factor is permissible, not quotas. Not race as a factor that outweighs everything else, but race as a factor in order to ensure educational diversity is permissible. So the University of Michigan is permitted to do that. And the court also speaks in terms of, well, cross-racial understanding. You have individuals in a class. If it's all white, they're missing out on something. So you want diversity of ethnicity, of race, geography, all those kinds of things. So he quotes from his dissent in that case against affirmative action. Cross-racial understanding is not, of course, an educational benefit because students aren't graded on it. And then in the Schuett case, the good people of Michigan decided, well, we've had enough of this affirmative action stuff. So what they did was they sold the people a bill of goods, said, from now on, admission to our universities based on merit alone. No consideration of race. Merit alone. Of course, you could still get in, and they didn't prohibit getting in because of athletics. Getting in because mom and dad, right, gave money. Getting in because you came from North Dakota and we don't have too many students from North Dakota. A billion different things. Everything's okay, but race is out. Race is out. So you know darn well what the motivation behind this thing is. But Scalia says the dissent trots out the old saw. The old saw he's referring to is this Caroline Products. It's a footnote in a 1937 case, which has become the foundation of constitutional law with regard to civil rights and civil liberties ever since. But he apparently doesn't like it. The old saw he's talking about is, if there is a classification based on race, the government better have a good reason for it. If there's an infringement of a constitutional right, the government better have a good reason for it. That's Caroline Products. But he didn't like it. He says the dissent trots out the old saw derived from dictum in a footnote that legislation motivated by prejudice, such as this one in Michigan, right, against discrete and insular minorities, race, merits more exacting judicial scrutiny. So I'm against looking at this thing any more closely. Yeah, we know what the motivation behind this thing was. Favoritism for just about anything, but not if you're a minority, a racial minority. Now, you say, well, let's take a look at every single case decided by the United States Supreme Court since John Roberts became Chief Justice. Every single case involving any claim of discrimination, minority discrimination, which typically means black or Latino, discrimination against them. How many times did Scalia vote in favor of the racial minority? Not once. Not once. Of course, you know, to be fair, I mean, the liberals, they never, right, saw a case where a racial minority was complaining that they didn't think the racial minority was right, right? But, you know, on the other hand, and I'm making excuses for them, on the other hand, 14th Amendment equal protection was about protecting racial minorities primarily. The civil rights laws were about protecting racial minorities primarily. Not once. Not once. I mean, come on, connect the dots. And opposition, right? Every case. Now, what about when white people complain? Every time. White person complains about discrimination, votes in their favor every time. Right? All right. If there's anything that Scalia hated more than affirmative action, it was women's rights. If you were in my class, I'd say, okay, wait till we read the cases. All right. JEB case. That had to do with prosecutors eliminating from the jury, right, potential jurors because of their gender. The Supreme Court says, you can't do that. You're not allowed to do that. You know, equal protection. People are entitled to be on a jury, right? People are entitled to be on a jury. You can't discriminate against them on the basis of gender. And what does he say? Oh, it's an inspiring demonstration of how sternly we disapprove male chauvinist attitudes. I mean, now he's defending male chauvinist attitudes of our predecessors. And to pay conspicuous obeisance to the equality of the sexes. I guess he was against that. University of Virginia, that's the VMI case, the Virginia Military Institute case. Again, he's in the dissent. It's 7-1. He's the only one. He's the only one. I mean, the majority even got Rehnquist on that one, for crying out loud, saying that you cannot discriminate on the basis of gender, meaning you can't keep women out, right? And he says, in my view, the function of this court is to preserve our society's values, right? The values in 1878 when the Equal Protection Clause was ratified. And of course, I'm sorry, ladies, but it did not apply to you. It did not apply to you. And he's saying that's the end of the story. Didn't apply in 1878. It doesn't apply now, right? Not to revise them. And you say, well, maybe he was just a little bit angry with his colleagues at the time. Uh-oh. He gives an interview to a publication of the California Bar Association. The question, did I say 1760? I meant 1868 when the 14th Amendment was ratified. 1860. I don't think anybody would have thought equal protection applied to sex discrimination. Does that mean that we've gone off in error by protecting women? Scalia, yes. Sorry to tell you that. Certainly the Constitution does not require discrimination against women. The only issue is whether it prohibits it. It doesn't. Nobody ever voted for that. Yeah, I'm not making this up. What do you want? I'm not making this up. Oh, he was one of the greats, right? Okay. You know, and the interesting thing about him, to his credit, he knew that he was going to go down in history as a real reactionary. He knew that. And he was willing to do that because those were his beliefs. Gay rights. Okay, if there's anything he hated more than affirmative action and women's rights, it was gay rights. That's the worst. That's the absolute worst. Romer versus Evans. The good people of Colorado, they pass a law not too different from what the good people of North Carolina and Indiana have done recently with the transgenders. But what they did in Colorado, they said that no law is allowed that permits gays and lesbians to sue for discrimination. So anybody else can sue about discrimination, but if you're gay and lesbian, you've been discriminated against for that reason, you can't bring a lawsuit. All right? He said, the United States Supreme Court throws that out. He says, people are entitled to be hostile towards homosexual conduct. Lawrence versus Texas, 2003, the United States Supreme Court finally comes out of the caves, and they say you can't throw people in jail or convict them for being gay and lesbian. He says homosexual sodomy is not a fundamental right, and it can be criminalized like incest, bestiality, and obscenity. And then finally, in the same-sex marriage case, Obridge fell. He says in 1868, again, that's when the 14th Amendment was ratified, states limited marriage to one man and one woman. That's the end of it. Finally, just to finish up, a couple of cases from last term and how his absence makes a difference. Zubik versus Burwell. That was the Little Sisters of the Poor. And their objection to the contraceptive mandate of Obamacare. Remember, so you have, it's a federal law. First Amendment doesn't help out, but you have the Religious Freedom Restoration Act, the statute. And they're saying that for us to go through the procedures, that is, to notify the insurance company that we're not going to provide contraceptive coverage, so you should, violates our religion because we're facilitating contraceptives. We're facilitating the use of contraceptives. If Scalia were on the court, it would have gone 5-4 in favor of the Little Sisters, and they would have gotten an exemption from the law. However, he wasn't on the court, and almost certainly the court was divided 4-4. So what happens, I'm almost sure, was the doing of Chief Justice Roberts, who's very highly admired in the court. He gets the court together and he says, look, at oral arguments, both sides seemed to say that they could actually work it out. Okay, So he writes an opinion, but he writes it for the whole court, doesn't sign it, and he says, okay, work the damn thing out. We know you can work this out. You don't have to force the Little Sisters. And Little Sisters, you could accommodate Obamacare a little bit. Go back and work it out. That's what you had. If Scalia was on the court, it would have been 5-4 the other way. Union dues. May public employee unions require public employees to pay dues, some agency fees, not the total union membership, but just agency fees to defray the costs of collective bargaining, right? The current state of the law is yes, but there are at least 4 votes on the court to do away with that, overrule the prior decision, and say that if you're not a member of the union, you shouldn't have to pay even these agency fees. The court split 4-4. Scalia was on, it definitely would have been 5-4 against the agency fees. The union would have lost. Affirmative action, 4-3. It was 4-3 in favor of affirmative action. This was the last time the University of Texas case came to the court. It's 4-3. It's 4-3 instead of 5-3 because Kagan was not on the court. She didn't participate because she was part of the administration's efforts on behalf of the University of Texas and affirmative action. So it's 4-3. If Scalia was on the court, it would have been 4-4. It would have been 4-4. This United States versus Texas had to do with the president's use of executive order to defer deportation of undocumented aliens. The court split 4-4. Whenever you have a 4-4 decision, it's not a decision. Things just stay the way they were. There's actually nothing written. It just goes down 4-4. If Scalia was on the court, it would have been 5-4 against the president. Whole woman's health. You know, Texas came up with all kinds of restrictions. Health providers can't engage in abortion services unless they have privileges in a hospital within 30 miles. Well, most of these clinics, health clinics in Texas, are not within 30 miles of a hospital. So between that and other requirements for abortion clinics, it really reduced drastically the number of healthcare facilities for women. The United States Supreme Court threw it out 5-3. If Scalia was on the court, it would have been 5-4. It still would have been upheld. And McDonald, this was the case, the good governor of Virginia. The good governor of Virginia, he would help his friends, meaning those who donated lots of money to his campaign. He would get them invited to different important dinners and hook them up with other politicians. And in return, Rolexes, and this is according to Chief Justice Roberts' opinion, he got Rolexes, a Ferrari, a gown for his daughter's prom. And the Chief Justice says, boy, how tawdry can you get? And this may really be low. But the law doesn't prohibit it. The law does not prohibit that at all. 8-0 with Scalia, it would have been 9-0. In short, this is America. If something's going to be a crime, government, you got to spell it out, and you didn't spell it out. Why didn't they spell it out? Because the politicians don't want it spelled out. And Utah, this had to do with a stop of an individual, not an automobile stop. He's actually in a parking lot. He just exited a friend's home. They stop him. They don't have probable cause. They don't have a warrant. They don't have reasonable suspicion. They concede all this. But they stop him. They ask him for his ID, all of which is illegal, and everybody on the court concedes this is illegal. Once they get his ID, they go into the cop car. They look up his ID, and there's an outstanding warrant because he hadn't paid a traffic ticket. Once he hadn't paid a traffic ticket, according to the Supreme Court's rules, but not Vermont. Vermont Supreme Court's much better than the United States Supreme Court. The United States Supreme Court says under the federal Constitution, once you got a warrant, I don't care what it's for. I don't care if it's for a parking ticket. You get to arrest the person? Yeah, handcuffs. You get to bring him down to the jail. Full search. In fact, in the Florence versus Burlingame County case 2 years ago, strip searches twice because somebody didn't pay a traffic fine. which he actually had paid, but that was irrelevant because the Supreme Court says, well, that's just a good faith mistake. But so what the Supreme Court said in this case, because there was this outstanding warrant, that basically wiped clean the stop, and therefore the search of this guy was perfectly legitimate. If Scalia was on the court, it just would have been 6-3. Wouldn't have been a change. Life without parole for juvenile offenders. This had to do with whether or not we applied the court's precedent in the Miller case, which said that's not allowed. Life without parole for juvenile offenders is not allowed. The question in this case is whether we apply this precedent to all those cases, right, that are still in the pipeline. Still in the pipeline. The court says yes. Scalia was still on the court. He said no. Ooh, one of the interesting things is Chief Justice Roberts, who actually in the Miller case was in dissent with these three, he now joins. It's one of the reasons why he's admired within the court. I mean, he's a real legalist. The future of the court. Obviously, if Hillary is elected, the balance is going to change in favor of the liberals. If Garland is appointed, and he's probably not her first choice, like most Democrat and Republican presidents of the last few generations, they like to appoint real ideologues, real partisan ideologues to the court. He's not that. He's not that. But even though he's not a partisan ideologue, he's still so much more liberal than Scalia is that even he would swing the court. Even he would swing the court to the left. And there it is. That's the way these guys vote. Look at this. Ginsburg, Breyer, Sotomayor, Kagan. How often they vote like a Republican politician does? How often they vote like a Republican politician? That's the court. That's just the flip side of it. Finally, in Catholic terms, reactionary. Now, I'm not sure how many of you are familiar with Vatican II or Vatican I, but it's important to understand Scalia. In the Catholic Church, Vatican II was John the 23rd. The Catholic Church revised a lot of its teachings and a lot of its approaches. For example, Catholics no longer had to believe that Jews were going to hell for crucifying Christ, right? That was Vatican II. Not only that, but anybody could go to heaven for being good. You didn't have to believe all the dogma, right? So very, very ecumenical, right? Very, very ecumenical. Lots of Catholics absolutely hated that. Absolutely hated that, right? Scalia was one of them. Scalia belongs to the Tridentine part of the church, still insists on Latin masses. They don't like the current pope. They like the dogma, right? Their idea of the Catholic Church is dogma as opposed to the Sermon on the Mount. That's by and large the division. And Scalia fell firmly in the Vatican II haters. He's a pre-Vatican II Catholic. Once you understand that, a lot of what he has done falls into place. All righty? Okay, so thank you very, very much. I went over, but there's still some time for questions. Thank you. Thank you very much. Thank you. Thank you. What are your questions? Yes?
If there was a way to get a communication from Scalia.
What?
Right now.
Right now.
What are the chances of him saying, I made a couple of mistakes? Now that he's found out whether or not his belief.
Oh, you mean now that he's in,
Wherever.
now he's in where he believes and St. Francis is talking to him?
Right.
Well, if he's listening to St. Francis, he's probably going to say he's made some mistakes. But there are some people, Donald Trump, who refuse to say they've made any mistakes, right? Refuse to say they've made any mistakes. I can tell you the last time I saw Scalia my mentor at the University of Virginia, we have this lectureship for him every year where we invite one of the justices of the Supreme Court or somebody else, right? And they give a lecture to the entire university is invited. And then a few of us, you know, Professor Abraham's sidekicks, right? His little kids, right? We call it, Henry Abraham, we call it the tribe of Abraham. We all go out to dinner. Well, a few years ago, I think it was about 4 years ago, Scalia was the guest. Scalia was the guest. So Scalia is there. One of the reasons he's the guest, and this tells you also something about this guy's personality, because you've heard, for example, that he was good friends with Ginsburg. You heard how sociable he is. He is, well, he's Italian, for crying out loud. You see him, he hugs you, right? He's our lecturer. He gives a lecture at dinner time. At dinner time. Now, during the lecture, he's giving the lecture on his method of interpreting the Constitution. And he keeps mentioning homosexual sodomy. Exactly. That's what some of us say, oh, brother, right? Because, of course, he lost all those cases where the United States Supreme Court apparently put its imprimatur on homosexual sodomy. Yeah, like that was the issue. So, at the dinner time, the chief judge of the Fourth Circuit, that's the Federal Appeals Court in Richmond, Virginia, he gets up and he says, I want to say a few words, thanking Nino for coming to the Henry Abraham event this year and for being gracious enough to join us at dinner. Very, very nice. Scalia, I got to say a few words. And he then proceeds to talk about homosexual sodomy. And at my table, I wasn't at his table was over here. And by the way, Henry Abraham's wife refused to sit with him. So their table's there, my table's here. And at my table, we're looking at one another like, okay, this is really bizarre. This is really bizarre. What does homosexual sodomy have to do with after dinner remarks? Really weird. But let me say something really, really nice about him. At the end of that picture I showed you at the very beginning, at the end of the year at that party, right, after I had had a few mild confrontations, I mean, I'm a nothing. I mean, he was a justice of the Supreme Court, so confrontation is really hyperbolic. But at that party, and it's jammed, he literally makes his way through the crowd. He comes over, he puts his arm around me, and he starts talking to my mother in Italian, telling her, I mean, really, telling her what a wonderful son she has. Isn't that sweet? Is that sweet? Yeah. Yeah, go ahead. Right? I mean, right?
Reluctantly, yes.
No, you would have thought that he and I were best friends. You know, yeah.
Thomas tracked Scalia. I guess Thomas tracked Scalia.
Scalia tracked
and just about
Thomas.
all of their, all of their votes. What was that relationship like?
Very interesting. The scholarship that's been done about that, and I'm talking about those who have real inside information, people who talk to justices and talk to clerks. People always said that Scalia's got 2 votes because he's got Thomas in his back pocket. Apparently, it was really the other way around. It was really the other way around. A couple of reasons for that. First of all, like him or not, Thomas is principled. He just sticks to his guns. He has certain beliefs and he just sticks to them. Number 2, people really like Thomas. He is one of the favorites at the court. People really like him as an individual. He's very personable, he's very warm, he's jocular. People really like him. On the other hand, you know, Scalia, who was just as extreme as Thomas, was nasty. I mean, did you read his dissent in the Obamacare case? What he said about the Chief Justice? All the different gay rights cases, what he would say about Kennedy? The affirmative action cases, what he would say about O'Connor? The Jones case, the GPS case, where Justice Alito wrote the concurring opinion saying, you got to be crazy that there's got to be a trespass. It can't be about the trespass. It's got to be about monitoring somebody's movements, interfering with their privacy. The nasty things about it he said about Alito. So you can imagine. I mean, he didn't have too many close professional friends on the court, and he didn't have much influence on the court. In fact, there's a book that was written the year before last by Bruce Murphy, who has written several definitive biographies of Supreme Court justices. He wrote one on Scalia. And he said Scalia was a real disappointment to us conservatives. Not me, but I mean the conservatives. And he said the reason for it, by and large, is that he's so nasty and so extreme, he lost all influence on the court. He lost all influence. And I think that's part of the reason why he was so strident and part of the reason why he was so extreme, right? And frustrated. Yeah. But no, it was Thomas. People do like Thomas. That always seems to be a surprise to people. But people really like him. He's a nice man. Rehnquist was another one. People at the court loved Rehnquist. Even if they never agreed with him on anything, people really admired Rehnquist. They really admired Rehnquist. So yeah.
You talked about the
Politicization.
politicization of the court. Was this over a period of time? Was it gradual? Was it a particular event that triggered it? That, in your opinion?
Well, it's pretty traceable. Look at the last few presidents. Obama, who did he appoint to the court? Sotomayor. I mean, come on, give me a break. Give me a break. I mean, she wouldn't be on anybody's top 50 list, right? But she's Hispanic. He wanted to put a Hispanic on the court. And she's very, 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 very liberal. In political terms, she's very, very, very liberal. Kagan worked for him, right, as Solicitor General, very liberal. Maybe not as much as Sotomayor, but pretty darn liberal. Before that, George W. Bush, who did he put on the court? Roberts, who worked in the Reagan administration, very, very conservative, although he's moderating now, so the conservatives are starting to hate him. Alito, right, very, very, very conservative, also worked in the Reagan administration and the Bush administration. Before that, you had Clinton, right? Clinton, who'd he appoint to the court? Breyer and Ginsburg, very, very liberal, right? Before that, you had George Bush Sr., right? Which was interesting because George Bush Sr. is nothing like the Republicans are today, and he was nothing like his son and nothing like Reagan. Who did he appoint to the court? He appointed Clarence Thomas, very, very conservative. He also appointed, much truer to himself, Souter. And everybody says it was a surprise. It was not a surprise. If you knew Souter, you know Souter was a liberal. And sure enough, so Bush Sr. appoints Souter. He turns out to be a liberal. Oh my God, no, we knew he was going to be a liberal. But Bush was not a real right-winger. Okay, before then, Reagan. Who did Reagan appoint to the court? Rehnquist, Scalia, right? And he also appointed Sandra Day O'Connor because he wanted to put a woman on the court. She was very conservative, but then she moderated, right? Much like Kennedy and much like, I think we see Chief Justice Roberts. Before Reagan, we had Carter. He didn't have an opportunity. Before we had Carter, we had Gerald Ford. Gerald Ford, remember, this was right in the aftermath of Watergate. He didn't want to have a tough time. Country was already embroiled in what had just gone on. So what did he do? He appointed John Paul Stevens, who everybody liked, right? He was kind of a middle-of-the-roader, and like what happens to lots of these justices, the middle-of-the-roader, the conservative, after a while, they become very, very liberal. So they either see the light or become senile, right? Right? And before that was Nixon, right? Before that was Nixon, and Nixon made it his business, and he made it absolutely clear he was going to put law and order conservatives on the court, and that's what he did. So if you had to point anywhere where this really started, it really kind of started in the modern era with Nixon. But then it really, really, really escalated with Reagan, And now that's what happens. You know, that's why some people actually want divided government. Because Hillary gets elected, if she doesn't have divided government, you know what she's going to put on the court? She's going to put a very ideological liberal on the court. I may like the way an ideological liberal votes on the court. You know, I like the way Sotomayor votes on the court. But she's not voting like a judge. She's not voting, I don't think she's voting like a judge, right? You should put somebody on the court that votes like a judge. They shouldn't, in my view, they shouldn't simply vote like their political party. And that's the problem we have now. That's really the problem we have now.
Do you believe that term limits should be with the court also?
Yeah, if I could rewrite things, yeah, I wouldn't have life appointment. I wouldn't have life appointment, but I would still make it extraordinarily difficult to remove somebody from the court. But I might say, 15 years, 18 years. But I think even more important than that is to have the nominations staggered so that you don't get a president that gets to appoint 4 or 5 of them, right? I think that's a real problem. For example, if Hillary becomes president, you watch how young her nominees might be. Now, again, this is the United States Supreme Court. Look, Felix Frankfurter, one of the greats, he would say, to be on the United States Supreme Court, you need to be a philosopher, a historian, a lawyer, a minister, a sociologist, because those are the kinds of questions that come before the court, right? Whether or not women should have rights equal to men, that's not a legalistic question. That's a question about your views about society, right? How much privacy, that is protection from government search and seizures, are required in a free society? That is, which searches are unreasonable? That's not a legalistic question. You could look up unreasonable in the dictionary all you want. You're not going to get the answer to that, right? The rights of the accused. For example, even proof beyond a reasonable doubt. That's nowhere in the Constitution. The right to have a friend. That's not in the Constitution. The right to get married, that's not in the Constitution. The right to be intimate with your spouse, that's not in the Constitution. The right to have children, that's not in the Constitution. The right to raise your children, that's not in the Constitution. The right to have the Green Mountain Academy, that's not in the Constitution. None of those things are, right? So it's not as though you can look at text and you could say, oh yeah, freedom of speech, Green Mountain Academy. No, you can't do that. You have to say, like some of the greats would say, like Benjamin Cardozo, he said, what is necessary for a free society? How do we protect people in a free society? What amount of equality and justice and rights do we want to guarantee for people in a free society? Right? Those are tough questions.
Thank you.
Okay, well, thank you very much. Thank you. Thank you very, very much.